of the case plaintiff suits are that the plaintiff is an accredited advertising agency of defendant number 1 society since the year 2006 under rules and regulations governing conduct of advertising agencies full stop. It is averred in the plaint that plaintiff entered into an agreement dated 1/2005 with the defendant number 2 for providing advertising and marketing services including planning, preparing, placing advertisements on both print and electronic media full stop. It is averred in the plaint that initial term of the agreement dated 1/2005 was of 2 years, but under clause 1.1 this agreement was to automatically renew for continuing cycle unless a review is requested by either party, and clause 6 of the said agreement provided the method of payment full stop. It is further averred in the plaint that under clause 6.3 of the said agreement, it was agreed by the defendant number 2 that upon completion of job they will make payments within 30 days of all invoices raised by the plaintiff, and also further agreed in clause 6.4 that in case defendant number 2 fails to pay within 30 days, then they shall be liable to pay late payment surcharge to plaintiff at the rate of 22% on the total outstanding amount of each individual invoice full stop. It is also averred in the plaint that since entering into the business relationship, the plaintiff has provided satisfactory advertising and marketing services to the defendant number 2, and the plaintiff through all its invoices has reiterated the condition that in case no payment is made within 30 days of the receipt of the invoice, a 20% of finance charge (LPS) will be charged full stop. It is stated in the plaint that the defendant number 2, since the very inception of the business relationship, has delayed in making payments clearing invoices of the plaintiff in time, but the plaintiff, with the aim to avoid punishments from defendants numbers 1 and 4, pays dues of members, publications and broadcasters within stipulated time, and arranged these payments by the plaintiff through its own resources full stop. It is also stated that to resolve the issue of delayed and outstanding payments, various meetings were also held between the management of the plaintiff and defendant number 2, but no material progress was made, therefore, in order to maintain constant cash flow, it is necessary to charge LPS from the defaulting party, as charging LPS is a trade practice, which has never disputed or denied these claims of the plaintiff by defendant number 2, full stop.